Danforth. One who drives an automobile is an operator within meaning of the Motor Vehicle Act. Pontius v. McLean. Constitutionally protected liberties includes the right to travel. 13 calories Jur 3D pages 416. The claim and exercise of a common law right cannot be converted into a crime. Miller v. U.S. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Shearer v. Cullen. Statutes that violate the plain and obvious principles of common right and common reason are null and void. We could go on, quoting court decision after court decision. However, the Constitution itself answers our question: can a government legally put restrictions on the rights of the people at any time, for any reason? If we are to follow the letter of the law, as we are sworn to do, this places officials who involve themselves in such unlawful acts in an unfavorable legal situation. For it is a felony and federal crime to violate or deprive citizens of their constitutionally protected rights. Our system of law dictates that there are only two ways to legally remove a right belonging to the people. These are, 1. By lawfully amending the Constitution, or 2. By a person knowingly waiving a particular right. Here's an interesting question. Is ignorance of these laws an excuse for such acts by officials? Some of the confusion on our present system has arisen because many millions of people have waived their right to travel, unrestricted and volunteered into the jurisdiction of the state. Those who have knowingly given up these rights are now legally regulated by state law, and must acquire the proper permits and registrations. There are basically two groups of people in this category. 1. Citizens who involve themselves in commerce upon the highways of the state. For while a citizen has the right to travel upon the public highways, and to transport his property thereon, that right does not extend to the use of the highways as a place for private gain. For the latter purpose, no person has a vested right to use the highways, but it is a privilege. State v. Johnson. There are many court cases that confirm and point out the difference between the right of the citizen to travel, and a government privilege, and there are numerous other court decisions that spell out the jurisdiction issue in these two distinctly different activities. 2. The second group of citizens that is legally under the jurisdiction of the state, are those citizens who have voluntarily and knowingly waived their right to travel unregulated and unrestricted, by requesting placement under such jurisdiction, through the acquisition of a state driver's license, vehicle registration, mandatory insurance, etc. In other words, by contract. We should remember what makes this legal, and not a violation of the common law right to travel, is that they knowingly volunteer by contract to waive their rights. If they were forced, coerced or unknowingly placed under the state's powers, the courts have said it is a clear violation of their rights. When a person applies for and accepts a license or permit, he in effect knows the limitations of it, and takes it at the risk and consequences of transgression. This raises a very interesting question. What percentage of the people have applied for and received licenses, registrations and obtained insurance after erroneously being advised by their government that it was mandatory? Many of our courts, attorneys and police officials are just becoming informed about this important issue, and the difference between privileges and rights. We can assume that the majority of the people carrying licenses and vehicle registrations have no knowledge of the rights they waived in obeying laws such as these that are unlawful, that is, laws of no effect, laws that are not laws at all. Government, in requiring the people to obtain driver's licenses, and accepting vehicle inspections and DUI/DWI roadblocks without question, is restricting, and therefore violating, the people's common law right to travel. Is this a new legal interpretation on this subject? Apparently not. This means that the beliefs and opinions our state legislators, the courts, and those in law enforcement have acted upon for years have been an error. Researchers armed with actual facts state that case law is overwhelming in determining that to restrict the movement of the individual in the free exercise of his right to travel is a serious breach of those freedoms secured by the Constitution. That means it is unlawful. There must be some way that a state can legally put restrictions, such as licensing requirements, mandatory insurance, vehicle registration, vehicle inspections, to name just a few, on a citizen's constitutionally protected rights. Is that so? For the answer, let us look, once again, to the courts for a determination of this very issue. In Hurtado v. California, the U.S. Supreme Court states very plainly, the state cannot diminish rights of the people. and in Bennett v. Boggs, statutes that violate the plain and obvious principles of common right and common reason are null and void. Would we not say that these judicial decisions are straight to the point, that there is no lawful method for government to put restrictions or limitations on rights belonging to the people? Streets and highways are established and maintained for the purpose of travel and transportation by the public. The right of the citizen to travel upon the public highways and to transport his property thereon, either by horse-drawn carriage or by automobile, is not a mere privilege which a city can prohibit or permit at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Emphasis added. Thompson v. Smith, 154 SC 579. So we can see that a citizen has a right to travel upon the public highways by automobile, and the citizen cannot be rightfully deprived of his liberty. So where does the misconception that the use of the public road is always and only a privilege come from? For while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways, either in whole or in part, as a place for private gain. For the latter purpose no person has a vested right to use the highways of the state, but is a privilege or a license which the legislature may grant or withhold at its discretion. State v. Johnson, 243 pages 1073. Hadfield, Supra. Cummins v. Holmes, 155 pages 171. Packard v. Banton, 44 SCT 256. And other cases too numerous to mention. Here the court held that a citizen has the right to travel upon the public highways, but that he did not have the right to conduct business upon the highways. On this point of law all authorities are unanimous. And the right of the citizen to travel upon the public highways and to transport his property thereon, in the ordinary course of life and business, is a common right which he has under the right to enjoy life and liberty, to acquire and possess property, and to pursue happiness and safety. It includes the right, in so doing, to use the ordinary and usual conveyances of the day, and under the existing modes of travel, includes the right to drive a horse-drawn carriage or wagon thereon or to operate an automobile thereon, for the usual and ordinary purpose of life and business. Teschlines v. Danforth, Miss, 12 S2D 784. Thompson v. Smith, Supra. Personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from nor dependent on the U.S. Constitution. It is one of the most sacred and valuable rights. Remember the words of Justice Talman, Supra. As sacred as the right to private property and is regarded as inalienable. 16 C.J.S. Kunst. Law, Sec. 202, pages 987.
As we can see, the distinction between a right to use the public roads and the privilege to use the public roads is drawn upon the line of using the road as a place of business, and the various state courts have held so. So what is a privilege to use the roads? By now it should be apparent that an attempt to use the road as a place of business is a privilege. The distinction must be drawn between 1. Traveling upon and transporting one's property upon the public roads, which is our right, and 2. Using the public roads as a place of business or main instrumentality of business, which is a privilege. The roads are constructed and maintained at public expense, and no person therefore can insist that he has, or may acquire, a vested right to their use in carrying on a commercial business. Ex parte Sterling, 53 SW2D 294. Barney v. Railroad Commissioners, 17 pages 2D 82. Stevenson v. Benford, Supra. We know of no inherent right in one to use the highways for commercial purposes. The highways are primarily for the use of the public, and in the interest of the public, the state may prohibit